This is Barry Zelma on insurance. Today I'd like to speak about the determination of actual cash value in a first-party property loss when subjected to an insurance appraisal to determine the amount of actual cash value loss. Now, determining the actual cash value of an item of personal or real property is often difficult and is subject to different interpretations across multiple jurisdictions. When an insurer and insured cannot agree on the amount of actual cash value loss, they have the right to seek appraisal, a limited form of arbitration that may only determine the amount of actual cash value and loss. In a case called Kirkwood versus California State Automobile Association, a 2011 decision of the California Court of Appeal, the Court of Appeal refused to allow an insurer to compel appraisal until the declaratory relief action filed by the insured to determine the proper method of calculation of actual cash value loss was first determined. The insured claimed it should be based on the condition of the property, while the insurer argued that it should be determined by replacement cost less physical depreciation calculated only on the age of the item. California Insurance Code Section 2071, the standard form of fire insurance policy, calls for an appraisal process to resolve disputes between the parties over the actual cash value of property loss claims. The appraisal panel's power is restricted to the factual task of valuing the items of property submitted for appraisal. Matters of statutory construction, contract interpretation, and policy coverage are not encompassed within the ambit of a Section 2071 appraisal. Douglas Kirkwood asserted that the California State Automobile Association improperly interpreted and applied the 2004 amendments to the California Insurance Code Section 2051, which set out the precise method of determining actual cash value of lost or injured property under an open policy of fire insurance. CSAA asked the trial court to compel appraisal. The trial court denied, without prejudice, CSAA's motion to compel appraisal, reasoning that Kirkwood had properly invoked its declaratory relief powers to resolve a matter that was outside the scope of a statutory and contractual appraisal. Kirkwood was insured by CSAA under a homeowner's policy. It was an open policy in which the value of the covered items was not agreed upon, but was left to be determined following a loss. The policy provided that CSAA would pay actual cash value or the replacement cost of lost or damaged personal property. He submitted his personal property claim to CSAA, setting forth a physical depreciation amount based on the actual condition of each item at the time of loss. CSAA provided Kirkwood with a contents inventory summary, which showed that a blanket depreciation schedule was applied to certain categories of property. For instance, many items were depreciated at 50 to 80%, and the depreciation was tied to the age of the item without regard to its condition. The Court of Appeal concluded, quote, "We think the trial court was right in its conclusion that an appraisal was not mandated right now because the declaratory relief cause of action asked the court to make a declaration that CSAA was misconstruing Section 2051B. Denying the motion to compel appraisal without prejudice, the court was clear. Subquote, I don't see how the plaintiff gets out of an appraisal later. Close subquote. In other words, given the limited role of an appraisal, the court essentially bifurcated the case, determining that it should first issue a declaration on the statutory issue and then have it inform the appraisal when it goes forward. In short, the court ruled that the agreement to arbitrate did not include the threshold contract and statutory interpretation issues, which were beyond the purview of the appraisers. Close quote. Although an appraisal is a special form of limited arbitration in California, there are significant differences between the powers of an arbitrator and those of an appraiser. An arbitrator's role is more like that of a judge in a judicial proceeding. On the other hand, Section 2071 calls for an informal appraisal proceeding unless the parties mutually agree otherwise, with no depositions, interrogatories, and the like, no formal rules of evidence, and no court reporter. The direction to maintain informality in appraisal proceedings was inserted into the statutes in 2001 in response to complaints of insurer abuses after the Oakland Hills fire of 1991 and the 1994 Northridge earthquake. Specifically, it was inserted in an effort to equalize the positions of insurers and insureds and to streamline the appraisal process. Appraisers have no power to interpret the insurance contract or the governing statutes. The function of appraisers is to determine the amount of damage resulting to various items submitted for their consideration. It is certainly not their function to resolve questions of coverage and interpret provisions of the policy. A judicial declaration that CSAA's interpretation of the statute and its policy did not violate the statute and would have been the end of the line, and no appraisal would be necessary. Insured such as Kirkwood would not have been forced to pay for an appraisal. On the other hand, a contrary judicial declaration would have informed the appraisal in the Kirkwood case and would have had the meritorious effect of staving off future appraisals and litigation based on the same allegedly unlawful behavior. For that reason, the court concluded that judicial economy favored resort to declaratory relief by heading off duplicative future actions challenging CSAA's statutory interpretation as reflected in its adjustment policy to depreciate personal property by a percentage based only on the age of the item. An appellate court found that the trial court erred in finding that appraisal was not mandatory under the language of the insurance policy. Florida law permits retained rights provisions, and these provisions do not render the appraisal clause unenforceable. Consider State Farm Fire versus Lycia, a 1996 decision of the Florida Supreme Court. Hence, the trial court erred to the extent it found that an insurance company could not demand an appraisal due to the language of the appraisal clause being unenforceable as inconsistent and violative of public policy. This was Cincinnati Insurance Company versus Cannon Ranch, a 2014 decision of the Florida Court of Appeal. In Texas, an appellate court concluded that a trial court finding that the insurance appraisal provision in an insurance policy was not an arbitration agreement, making Texas completely different than California, which does find that appraisal is an arbitration agreement. In Texas, the district court erred by reviewing the appraisal award. Hartford was denied a jury trial on the validity of the award. Under Texas law, it appears that the validity of an appraisal award may be tried to a jury. Now, insurance policies sometimes define the term actual cash value, and by so doing, take it away from various interpretations. Depending on the actual wording of the policy or local state law, actual cash value can be determined by subtracting from full replacement cost depreciation based on the age and usefulness of the property involved. In other jurisdictions, or because of various modifications to policy wording, ACV can be the difference between the fair market value of the item before the loss and its fair market value after the loss. Some states, giving everything to everyone, apply what is called the broad evidence rule and will take into consideration the use of depreciation, consideration of fair market value, or any other evidence that will provide true actual cash value to an insured. Limiting coverage to actual cash value does result in lower premiums, but it could end up leaving the insured with a large gap between the amount of the indemnity recovered after a loss. ACV may not be sufficient to rebuild the dwelling or replace its contents. For example, if the structure of the dwelling is in poor physical condition, is old, or was constructed with a design that is no longer popular, its fair market value might be very small, with most of its value in the land. In some cases, the structure even detracts from the full value of the land, and structures so its ACV may be zero, while its replacement cost could be $500,000 or more. It is important and imperative, therefore, before selecting a policy limit, that the insured understand that the structure's actual cash value and its full replacement value are adequate for the insured's needs. In one case I had to work on many years ago when I was a young, just starting out lawyer, the actual cash value of a dwelling was found to be less than the actual cash value or fair market value of the land upon which it sat after the house was removed from the property, so that the existence of a piece of real property that was totally valueless, the insured only recovered after a fire loss the cost to demolish the fire-damaged structure. And in essence, by the accidental fire, turned out to be a profit-making situation for the insured. So, it is always best when purchasing dwelling insurance like a homeowner's policy to buy one that provides full replacement cost coverage, new for old, in the case of a loss. In such a situation, the insured is able to collect the actual cash value of the loss immediately and use those funds to replace the structure. And once the full amount of replacement cost is expended, the insured can then collect from the insurer the difference between actual cash value and replacement cost and will be made totally whole. This video was adapted from my book, The Homeowner's Policy Handbook, which is available as both a Kindle book and as a paperback from Amazon.com. If you found this video to be interesting or useful to your colleagues, please pass it on. It's free. And please subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications so that you can be advised of future blog postings and future videos, as well as other publications that are available at the Insurance Claims Library portion of my website, zalma.com. Thank you for your attention.